number 2?
Yes, Your Worship.
And applicant number 3?
Yes, Your Worship.
Thank you. You may be seated. We will start with the affidavit for applicant number 1. Whilst the reading of your affidavit, Mr. Jordaan, you may stand up for that purpose. When we get to the second applicant, then you may be seated and we will attend to Mr. Neathlin. Thank you. Mr. Nkwashu?
As this is Your Worship, as stated, Your Worship, that the application will be by automatic. With the leave of the court, we request permission to hand in the original while I read the contents of the court into the record.
Thank you. You may proceed.
This is Your Worship. The original division of Paute held at the Specialized Commercial Crimes Court, Palm Beach. The matter between Daniel Alexander Jordaan, the applicant, and the state is the respondent. Affidavit by the applicant for bail as understood in section 60, subsection 11, paragraph B of the Criminal Procedure Act of 1977, bracket the CPA. I, the undersigned Daniel Alexander Jordaan, hereby make an oath and state that I'm an adult male African citizen, currently 72 years old, and I'm the applicant to this application. I make this affidavit on my own free volition and has not in any way been unduly influenced by any person. The facts herein contained are said where expressly indicated in contrary with my personal knowledge and belief and according to the fact. Where I make submissions of law based on the advice of my legal representatives, which advice I verbally believe to be correct. I'm advised that I face charges of contravening section 18 subsection 2 of the Righteous Assemblies Act 1965, fraud and theft. No further details were provided to either me or my legal representatives regarding the particularity of the charges. I have first learned about this investigation since the case was reported in May 2020 in the presence of different media houses at Boyson's police station. I was also informed that the matter was investigated by the Directorate of Project Crimes Investigations, in brackets DPCI, colloquially known as the Hawks. I've also been in constant communication with both the investigating officer and the state prosecutor through my attorneys on record. I have pledged my undivided cooperation and lived up to my pledge. When I was requested by the police to provide information, I did so and even submitted a written statement with supporting documentation through my attorneys on 15 December 2022. Both the state and the police will confirm this fact. On 8 March 2024, the investigating team conducted a search and seizure operation at Safa House in my absence. I was only informed that they did not search my office, but only conducted a search and seized certain documents and electronic equipment in the office of our Chief Financial Officer, Mr. Gordon Kluge, who is in charge in this case. Following the much publicized raid at Safa House on 5 April 2024, the leadership of South African Football Association SAFA took a decision and instructed our attorneys of record to challenge the lawfulness and validity of the search and seizure operation through the review process, and the matter is currently pending in the High Court Johannesburg under case number 2024-035799. I've been advised by my attorneys that the pleadings have closed and that the heads of argument are currently being drafted and the matter is hard for a hearing and an explanation could be raised. The state is well aware of this position. On Thursday, 7 November 2024, my attorney was contacted by an investigating officer to inform me that there is a warrant for my arrest and that he needed to have a discussion with me over the phone. Indeed, the investigating officer called me on 11 November 2024 and informed me that he wanted me to hand myself over for arrest on 30 November 2024 at 0700 hours in the morning at his office. I gave an instruction to my legal team to offer my full cooperation to Captain Mohammed and the state. However, due to the communications from the office of the senior judge who involved in interviews to pen this arrest until the review is regulated, I was advised that both the NPA and the state attorney will be preparing the answer affidavit, which is due this evening at 300 hours in the evening. And the hearing of the matter is scheduled for 10 a.m. tomorrow, 14 November 2024. I did not end myself in for arrest, however, the police came to fetch me at my house and brought me before the schools. All communications between my attorney, the state attorney, and the senior judge were forwarded to both the NPA and the DPCI, and hence I was advised that the application in the High Court would have to take precedence over this arrest. I will consider my position once I would have consulted my legal team about what has transpired here today. Previous convictions of any cases. I'm advised that in terms of Section 60, subsection 11, capital B of Act 51 of 1977, I'm compelled to disclose to this court any previous convictions or pending cases that I may have against me. I have no previous convictions either in the Republic of South Africa or elsewhere. Save for this matter, I'm not aware of any pending warrants of arrest against me. I further confirm that I do not have any cases pending against me in any other criminal courts. I'm advised that should I willfully fail to refuse or furnish this court with false information regarding my previous convictions or cases pending against me, I will be guilty of an offense and liable on conviction to a fine or imprisonment for a period exceeding 2 years or both. Further, that my bail may be cancelled and I may be required to remain in custody until my trial is finalized. I've also been advised that by virtue of the fact that the allegations against me involve offences in monetary value of about 500,000, my bail applications fall within and has to be dealt with in terms of Section 60, subsection 11, subparagraph B, where the schedule part of the Criminal Procedure Act is going to be 1977, the Act. I submit therefore that it should be incumbent upon me to adduce evidence and demonstrate on the balance of probabilities that the interest of justice can be my release on bail. The purpose of the application. I propose to this application to set out facts to demonstrate to this court that it is in the interest of justice for me to get released to bail rather than to remain in detention while awaiting trial. In so doing, I'm advised that Section 60 of the Act imposes stringent conditions for the granting of bail where a person stands accused of offences referred to in part of the Act. Section 60, subsection 4 to Section 6, subsection 9 of the Act specifically sets out factors which ought to be established by me and considered by this court before bail is or is not granted. I shall later deal with these factors. Personal circumstances. I'm a South African citizen with identity number 51090350880088 and the serving President of SAFA since the year 2013. I was previously the Chief Executive Officer of SAFA from 1997 until 2012. As President of SAFA, I render my services on a voluntary basis with no salary paid to me. I'm however offered an honorarium payment once a year ranging from no cent to approximately 100,000, depending on the performance of the association. As indicated in paragraph 1 above, I'm 72 years old, adult male born in Port Elizabeth, now Gqeberha, in the Eastern Cape Province, South Africa. I'm permanently resident number 12 West Road, South Estate, Farrington Street, Morningside, Johannesburg for the past 14 years. This property is valued approximately 6 million rand. I'm also the registered owner of housing Gqeberha, situated number 6 Fifth Avenue, Summerstrand, Gqeberha. I also live in this house with my wife, with whom we share 2 adult children aged 40 and 24 years old. This property is valued at approximately 4 million rand. I have household furniture, appliances and fittings in both houses, valued at approximately 2 million rand. I have 2 vehicles, a 2011 Mercedes-Benz valued at approximately 500,000 rand, and a 2006 or 2007 BMW sedan valued at approximately 250,000 rand. I do not have family or any financial interest or assets in foreign countries. I also do not have any intentions of relocating elsewhere beyond the borders of RSA. I owe my complete allegiance to South Africa. Due to the nature of the office that I hold, I undertake to inform the state should I be required to undertake any foreign trips and produce my travel itinerary as proof of my departure in 10 days. The merits. I've been cautioned against disclosing the basis of my defense at this stage, which advice I also accept. For purposes of this proceedings, I have detailed the manner in which I was arrested, paragraph 6 to 12 given above. I would have liked to take this court into my confidence with regard to the merits of the case. However, at the time of drafting of this affidavit, the state had not provided my legal representatives with the copies of the docket or the charge sheets. I have, however, provided a statement on the request of the investigating officer with supporting documentation, the issue that is so clear to told me in 2022 already. From the cursory reading of the warrant of arrest, I intend to plead not guilty to all the charges, and I believe that I will be acquitted because the state has no case at all against me. I am of the well-considered view that this arrest is an abuse of the process because of the pending review application in the High Court as mentioned above. This is so because if the High Court finds in our favor, I would have suffered irreparable harm by this arrest and prosecution, even in circumstances where the state is well aware of the pending review application, but still elected to arraign me on these charges. The provisions of Section 6, subsection 4, paragraph 8, read with Section 6, subsection 5 of the Act. There is no likelihood that my release on bail will endanger the safety of the public or any person, or that I will commit a Schedule 1 offense. At the age of 73, I have no previous convictions and no pending case against me. I am not a violent person, and the offenses for which I will be charged do not involve any degree of violence or threat, implicit or otherwise thereto. Section 60, subsection 4, subparagraph B, read with Section 60, subsection 6 of the Act. I have strong emotional, family and community ties within the Republic of South Africa. As indicated above, I am married and have 2 children who are adults. I am a well-known person in South Africa, or RSA. I have been elected and assigned a lot of responsibilities by SAFA on behalf of the people of South Africa. Therefore, I do not intend to jeopardize my repute or status by evading my trial or doing anything that is likely to interfere with the prosecution of this matter. As stated, I have known about this investigation against me for the past 5 years, and I have cooperated with the Hawks. I have not attempted to flee as I believe in my innocence. For this reason, I have fully cooperated with the investigating officer and handed myself in for arrest after the state contacted my attorneys to the point. I trust and have confidence in the South African legal system and firmly believe that everyone deserves to be treated in terms of the rule of law. I did not commit the offenses for which I have been accused of for many years now. I undertake to comply with any bail conditions pending the finalization of these proceedings. I submit that it would be unthinkable for me to evade my arrest or my trial, as doing so will adversely affect the people I so dearly love and my responsibilities which have been elected and entrusted by the people of this country and South Africa. I respectfully submit that the facts set out above support my contention that I do not constitute a flight risk and that I have no reason not to stand my trial and proceed against me. Further, I have a vested interest in seeing that justice is seen to be done. I am confident that the state will dismally fail to prove their case against me because there will be no objective evidence that will support their case against me. I will be acquitted of the trial. Section 6, subsection 4, subparagraph C, read with Section 6, subsection 7 of the Act. In view of the fact that I do not know the specific charges against me, I am uncertain whether I know the identity of the witnesses the state intends to call. I can only presume that these charges were laid by disgruntled former employees of SAFA. I have not been provided with a list of witnesses by the state. That notwithstanding, I hold no resentment wherever the state interests me. I have no intention to interfere with or intimidate any of them, directly or indirectly, and I undertake not to do so. I also undertake not to communicate with any witness, whoever he or she may be, and any other persons whose names may appear on the list of state witnesses to be provided by the state. I maintain good relationships with people, and I bear no grudges against anyone. I will comply with any bail condition in this regard. I have no knowledge of any evidential material which may exist with regard to the allegations that are against me. In any event, I believe that whatever such evidence may be is in the possession of the police. It is safely secured, and I do not have access thereto. As stated elsewhere in the affidavit, the police conducted a raid at SAFA House, and they did not search my office. Besides, I was advised that the investigations are completed, and hence the state applied and were granted warrants of arrest. In the circumstances, I submit that there is no likelihood that I will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Section 6, subsection 4, subparagraph D, read with Section 6, subsection 8 of the Act. As alluded to also in this affidavit, I still regard myself as a permanent member of the society. I have been aware of the investigation and possible prosecution since early May 2020, and I have done nothing to suggest that I will undermine the proper functioning of the law or jeopardizing the investigation or disturb the public order. I've always waited for the legal process to take its course. Accordingly, I respectfully submit that should I be released on bail, my release shall not disturb the public order or undermine proper functioning of the criminal justice system. Section 6 subsection 4, subparagraph E, versus section 6 subsection 8, capital A of the Act. I'm advised that the consideration under these subsections do not arise as the bail application relates to Schedule 5 and not Schedule 6. Section 6 subsection 9 of the Act. I'm advised that due to the fact that this matter involves more than one accused and several charges, it is likely to take considerably a long time before it's finalized. I need to raise funds in order to pay for my legal fees. If I'm not granted bail, I will suffer substantial prejudice owing my detention and trial. In all likelihood, there may be thousands of documents involved in this matter, including the ones that are submitted to the Hawks. Accordingly, keeping me in custody will also hinder me from preparing for the trial adequately. I'm advised that the state has no intention to oppose my release on bail. I will comply with any condition that this court may impose. I accordingly submit that the interests of justice, considerations of prejudice, and the balancing of respective interests from my release on bail, the refusal of bail can only prejudice me and creates no benefit to the state. In the premises, I submit that I've made out the proper case to indicate that it is in the interest of justice to release me on bail. Should this court consider to release me on bail, I have raised an amount of 10,000 rand to process bail and cannot afford to forfeit the same. Wherefore, I humbly pray that this court admit me to bail in an appropriate amount in such conditions as this court may deem appropriate. The affidavit has been properly deposed to your worship, commissioned by a commission of oath. There are several annexes of communications between the offices of our office as well as the High Court, as well as the office of the state and the DPCI, which form part of the annexes that are referred to the affidavit. I first wish to accept this affidavit and make it accordingly as an exhibit after the accused has confirmed the purpose.
Thank you, Mr. Nkwashu. Thank you, Mr. Jordaan. Did you understand the content of the affidavit read into the record on your behalf?
Yes, Your Worship.
Do you confirm each and every fact contained therein to be true as well as accurate?
Yes, Your Worship.
Thank you. The affidavit in support of the first applicant's application for bail is received and marked Exhibit A to the record. All right, thank you. Mr. Jordaan, you may be seated. Mr. Nkwashu, is that the application for applicant number 1?
That is correct.
Thank you. We'll turn to applicant number 2, Mr. Neethling. You may stand up. Thank you, Mr. Ndebele.
Your Worship, for experience, may I, with the leave of the court, request the original statement and it to the court. I'll read from the copy there of Your Worship.
Thank you.
May I begin?
You may proceed.
Statement in terms of the provisions of Section 60, Sub 11, Sub B of the Criminal Procedure Act number 51 of 1977. I, the undersigned, Trevor Adrian Leading, do hereby make oath and say that I'm an adult male South African citizen and businessman with identity number. Your Worship, I beg leave to exclude reading out the accused identity number due to the fact that the proceedings are being televised. Your Worship.
Thank you. You have my permission. It is recorded in the affidavit. You have my permission. Thank you.
I make this affidavit of my own free will and have not in any way been unduly influenced to depose thereto. The facts herein contained, save where expressly indicated to the contrary, are or is apparent from the context, are within my personal knowledge and belief and are both true and correct. Where I make allegations of a legal nature and or draw conclusions of law, I do so on the strength of advice received from my legal representatives, which advice I verily believe to be correct in law and accept. I am the applicant herein. I have been informed that I have been charged with offences which constitute Schedule 5 offences in terms of the Criminal Procedure Act number 51 of 1977, quote, open bracket, the CPA, close bracket. I have been further advised that I bear the honours and am obliged to demonstrate to the court that it is in the interest of justice that I be released on bail. I have elected to lead evidence by way of a written sworn statement, affidavit, as a means of demonstrating that the interests of justice permit and require that I be released on bail. Made application in terms of section 60, sub 11B of the CPA. In this affidavit, I deal with my personal circumstances and the factors to be considered by this honourable court as contained in section 60, sub 4 to 9 of the CPA. As aforesaid, I have been advised, accept, and understand that I bear the honours to establish to this honourable court that the interest of justice permits that I be released on bail. This is provided for by section 60, sub 11, sub B of the CPA, which is instructive in this regard. My personal circumstances are as follows. I was born in Port Shepstone, KwaZulu-Natal on 9 August 1978. I have resided in the Republic of South Africa for my entire life. I am married with 2 children, aged 25 and 16. Lordship, I again beg leave to omit reading out the address of the accused.
Thank you.
I have resided at this address for longer than 5 years, and I have no immediate intentions at this stage and or in the foreseeable future to move to another place of residence. I earn an income of 45,000 rand a month. I hold a Bachelor of Arts Honours in Media Studies, which I attained at the Nelson Mandela University. I have movable property to the value of approximately 350,000 rand. I have immovable property to the value of approximately 2 million rand. I do not have any family and or assets outside the Republic of South Africa. I am in possession of an expired passport. I recently applied for another passport which is yet to be issued. Should the need arise, I am prepared to surrender my passport to the investigating officer immediately upon receipt of the issued passport. I have never been convicted of any criminal offence. I am not aware of any criminal investigations pending against me, outstanding warrants of arrest, and I have not been released on bail pending any criminal charges, and I have been advised by my legal representatives, which advice I accept, that if I fail to disclose any previous convictions and or pending cases, I may be criminally prosecuted. My legal representatives have advised me that during bail application proceedings, I am presumed innocent until proven guilty at the trial, which is likely to take place much later. I have been advised also that at this stage, my guilt, when all I have, is not a primary and or sole consideration for the court. I have been further advised that I need not testify regarding the merits of the matter, and that if I elect to testify, whatever I say under oath during these proceedings will be used against me during trial proceedings. I accept my legal representative's advices. On the contrary, I believe that it is necessary and appropriate to take this honourable court into my confidence by providing pertinent aspects and evidence, knowing and understanding that in the unlikely event of this matter proceeding to trial, such evidence may be admissible at such trial proceeding. I am the sole director of Grid Communication Pty Limited. The allegations against me and Grid Communication relate to commercial service agreements concluded between Grid Communication and the South African Football Association. At the outset, I deny in the strongest terms all the allegations against me or Grid Communication. In particular, I deny having committed the offences, acted in concert with certain individuals at SAFA and or participated either directly and or indirectly in any blameworthy conduct. Such allegations are not only frivolous and vexatious, but unjustified, unfounded, and lack any merit in law and of fact. I respectfully submit that such allegations are an abuse of court process and the criminal justice system. Being an abuse of process, the complainant and the charges violate the constitutional principle of legality. The facts clearly demonstrate that I cannot be found wanting on any of the allegations of impropriety as alleged. I detail below the background which aptly demonstrates my innocence and or that of Grid Communication. Grid Communication is a communication services provider. The company provides reputation management, communication, and media relations advisory to various clients within the South African market. Since 2013, Grid Communication has been contracted by numerous organizations to provide media relations and communication services. One of Grid Communication's clients was SAFA, in respect of which these unfounded allegations relate. Having considered all the facts and circumstances, it is clear that Grid Communication and myself are collateral damage of factionalism and infighting within and outside SAFA as an organization. I condemn this and appeal to the individuals who are using my name and Grid Communication not to involve us in SAFA's battles, which appear to be intensifying due to SAFA's upcoming elective conference. I also appeal to the authorities to see the allegations and context for what they truly are, an abuse of process. Neither I nor Grid Communication have personal or private business relationship with SAFA President Dr. Jordaan or any individual within SAFA. Grid Communication simply had a contractual relationship with SAFA and not any individual. There are agreements to confirm this, which are conclusive evidence of a legal relationship between Grid Communication and SAFA. Grid Communication duly and lawfully concluded a service level agreement with SAFA to provide strategic communication advisory services to SAFA. The agreement was signed by myself for Grid Communication and on behalf of SAFA by Dr. Jordaan, being the highest official within SAFA. SAFA provided warranties that Dr. Jordaan was duly authorized to sign and or execute the agreements. I never had any reason to doubt the authority of Dr. Jordaan. The agreement was for an initial period of 12 months, which was extended from 1 October 2018 to 31 August 2019. For each services, Grid Communication and SAFA agreed on a monthly retainer fee of 80,000 Rand excluding VAT. The main objective of engaging Grid Communication was for enhancing SAFA's corporate reputation of the organization through a structured PR and communication program. In delivering on its mandate, Grid Communication reported to and engaged with various SAFA officials and executives, including the former Chief Executive Officer, Mr. Dennis Mambo, SAFA's then Communications Manager, Dr. Dominic Chilmavi, and Dr. Jordaan. There is various communication with the above-mentioned individuals where they made input into the work provided by Grid Communication. I personally interacted with SAFA's officials and executives, and none of them, in particular, Mr. Mambo, ever raised any concern about the agreements between SAFA and Grid Communication. The allegation that the service level agreement between SAFA and Grid Communication was concluded during about December 2017 is rebutted by the fact that on 8 November 2017, Ms. Tikani Baloi from Dr. Jordaan's office transmitted an email of the signed service level agreement to me by email. Mr. Shuyo was in copy of such email. On 10 November 2017, Mr. Shuyo responded to the aforesaid email correspondence wherein he advised as follows: Dear Trevor, thanks for the signed agreement. My CEO, Mr. Dennis Mambo, would like to meet with you next week to discuss the scope of this agreement. I will ask his PA to set up the meeting with him. Are there any specific days that you are available next week to meet him? Close quote. A copy of the aforesaid thread of email correspondence is annexed here to Mark A. Annexed here to Mark B1 to B3. Some of the plethora of email correspondence are exchanged with all the aforesaid SAFA executives. In one of the aforesaid attached emails, B1, Mr. Mambo responds to my draft media release and requests for comments as follows. Dear colleagues, I think this is fine. However, I would have wanted to drop something in there that shows how well SAFA's presentation and strides in women's football impressed the participants in the symposium in Morocco. Close quote. On Annexure B2, Mr. Mambo provided the following comments responding to one of my draft media statements. Dear Trevor, can you please ensure that this is sent through the SAFA portal and not from your address, as it is an official SAFA communication? Also, Please ensure that you mention that this is in line with pillar number 6 of Vision 2022, and also name some more of the key cities where the President travels to drive home the point that he can travel anywhere in the world without restriction. This has all been said in a non-election campaign context, and we can safely state this. Please also mention that the President is a member of the CAF Executive Committee, and he, along with other SAFA leadership, is regularly called upon to share expertise without making this a campaign speech on behalf of the President. Please also don't write me or other council members out of these releases, as it will prevent the impression that it is an election leaflet. Close quote. It is evident from the above that Mr. Mambo's allegation that Grid Communication did not render any services for SAFA is a blatant lie and contemptuous abuse of process. Nothing could be further from the truth. It is evident that Mr. Mambo actively engaged with Grid Communication, participated and utilized its services for several months. Grid Communication addressed all billing matters to SAFA's Chief Financial Officer, Mr. Crowley Julio, and or his duly authorized representative. According to the agreed terms of the agreement, at no stage did any SAFA official or executive communicate to Grid Communication or to me that payment was being challenged or otherwise unlawful or improper for that matter. I was never aware of the intricacies of authorizations within SAFA. Safe to say that to me, Dr. Jordaan was the highest official, and there was nothing which was raised to question his authority. In any event, we relied and acted on the basis of warranties of authority provided by SAFA and never questioned. Throughout the engagement with SAFA, no one ever raised or questioned Dr. Jordaan's authority to sign the agreement, including Mr. Mambo. In the many engagements over a period of over 2 years, and for the duration of the agreements, none of the SAFA officials or executives, including Mr. Mambo, communicated to me or Grid Communication that its agreement with SAFA was unlawful or otherwise indicated that Dr. Jordaan had not been authorized to conclude the agreement. Further, at no stage in all of its engagements over the duration of the contractual period did any SAFA officials or executives, including Mr. Mambo, communicate to me or Grid Communication that SAFA had not followed the organization's requisite procurement procedures. I find that Mr. Mambo's recent utterances to the contrary to be opportunistic, improper, and in fact amount to defeating the end of justice. Around 2018-2019, SAFA suffered a financial downturn. The organization negotiated with all of its creditors, including Grid Communication, a payment plan and reduction in the fees owed. Grid Communication acted in good faith and agreed to a 25% reduction in its fees on all outstanding invoices. In or around March 2019, SAFA's then acting CEO, Mr. Russell Paul, extended Grid Communication service level agreement by a further period of 11 months. Mr. Paul took over the reins as CEO from Mr. Mambo. I next here to Mark C, a copy of the extended service level agreement signed by Mr. Paul. I further next here to Mark D, a thread of email correspondence between myself and Mr. Julio and Mr. Paul, wherein the terms of the extended service level agreement were negotiated and agreed upon with SAFA. Grid Communication acted in good faith and duly obliged by providing services until the term of appointment expired. Again, no official or executive from SAFA objected to this or gave an indication that Grid Communication was being engaged unlawfully. Grid Communication simply performed or provided services in line with the agreement concluded between the parties. All invoices were duly submitted to SAFA for services rendered to SAFA, and there was never any theft and or fraud committed by neither myself or Grid Communication. While I'm cognizant that my statement in support of my release on bail need not contain matter which constitute legal argument, I beg this one to quote the authors and allow me to briefly address the issue of Dr. Jordaan's authority to sign Grid Communication's initial service level agreement. It is alleged that he lacked authority to sign the service level agreement in question. I have since been advised by my legal representative, which advises I accept that Dr. Jordaan was and is actually legally authorized to sign on behalf of SAFA, which authority is conferred upon him by inter alia SAFA's Articles of Association /statutes, which came into effect in 2015 and 2017 respectively. Article 37.1 and 37.2 of both statutes read as follows. 37.1. The President represents SAFA legally. 37.2. He/she is primarily responsible for, sub 1, monitoring the implementation of the decisions passed by the Congress and the SAFA Council through the Chief Executive Officer/General Counsel. Sub 2, ensuring the effective functioning of the bodies of SAFA in order that they achieve the objectives described in these statutes. Sub 3, overseeing the work of the Chief Executive Officer. Sub 4, promoting good relations between SAFA and its members, FIFA, CAF, political bodies, and other organizations. Article 39.1 of both statutes read as follows. Heading, representation, and signature. 39.1. The President and the Chief Executive Officer represent SAFA legally and are duly authorized to represent SAFA in any legal proceedings and are entitled to sign for and on behalf of SAFA. Except the aforesaid articles are next year to Mark E. As stated above, the pending action against me is as a result of unjustified allegations primarily by individuals who have left SAFA, who seem to have a personal vendetta or issue with Dr. Jordaan. I am of the view that Grid Communication and I should not be involved in that imbroglio. Individuals such as Mr. Mambo are seriously prejudicing me and violating my rights. They are in fact committing perjury, criminal injury, and defeating the ends of justice by their continued untrue and unjustified statements. I also believe that these individuals are intending to burden the already constrained state resources for what they know to be untrue as against me and Grid Communication. I believe that my arrest constitutes a serious abuse of process, violation of my rights and dignity, and would lead to a severe, if not irreparable, reputational damage for me and Grid Communication. I am of the strong view that there could be no criminal liability that could be properly imputed on me and Grid Communication for that matter. Neither myself nor Grid Communication committed any crime. I've fully cooperated with the investigating officer. In so doing, I surrendered myself for arrest and detention upon the investigating officer's special instance and request. I tender my full cooperation in the conduct and the process of this matter, which will not be delayed in any manner whatsoever. That said, I will not jeopardize the functioning of the criminal justice or bail system. In order to persuade this honorable court that I should be released on bail, I provide the following facts and information in terms of Section 60, Sub 4 to 9 of the CPA. Add Section 60, Sub 4A, read 60, Sub 5 of the CPA. I'm not fully aware of which witnesses the state will be relying upon to prove its case. I've made no threats of violence towards any person. I do not harbor any resentment against any specific person, and I have no disposition to violence and have no history of violent conduct. I have no disposition to commit any offense as referred to in Schedule 1 of the Criminal Procedure Act, and have at no time before being charged with or convicted of any offense whatsoever. As Section 60 Sub 4B, read with Section 60 Sub 6 of the CPA. I respectfully submit that the facts set out herein above support my submission that I do not constitute a flight risk. I have no intention of fleeing across the borders of the Republic of South Africa or in any way attempting to evade my trial. I accept that the charges leveled against me are serious. I am in a financial position to raise cash in the amount of 10,000 rand for the purpose of securing my release on bail. I certainly cannot afford to forfeit this amount should bail in the amount of 10,000 rand be granted to me. This contention is supported by my posted personal circumstances, monthly income, indisputable facts of the allegations in question, conduct in fully cooperating with the investigating officer, and surrendering myself for arrest and detention at the special instance and request of the investigating officer. I accordingly have no incentive whatsoever to attempt to evade my trial. The nature and gravity of any punishment which could theoretically be imposed upon me plays no part in my actions or decisions. I am prepared to submit myself to any bail conditions, however stringent they may be, which may be imposed on me by this honorable court. Add section 60 sub 4C, read with section 60 sub 7 of the CPA. It has never been and remains my clear intention not to communicate with any state witnesses. I have no access to any evidentiary material which may be presented at the trial. I am given to understand that the evidentiary material which the state may have against me is in the possession of the prosecution and the investigating officer, and I presume that it is safely secure. I am not aware of the existence of any other material which could be concealed, and I certainly will not conceal or destroy any evidentiary material. At section 60, sub 4, sub D, read in section 60, sub 8 of the Act. As aforementioned, I have no previous convictions. I have not been released on bail pending any charges to be brought against me. I am not on parole and I have never been accused of any other charge. At section 60, sub 4E, read with section 60, sub 8A of the CPA. I respectfully submit that should I be released on bail, my release will not disturb the public order or undermine the public peace or security. I further submit that my safety will not be jeopardized by my release on bail. At section 60, sub 9 of the CPA, I respectfully submit that the interests of justice do not require my further and or continued incarceration. Given my aforesaid cooperation, in particular, by having surrendered myself for arrest and detention, my continued incarceration will bring about an impediment, not only to me and my health, but my family, as I am the sole breadwinner. I respectfully submit that on the basis of the facts set out herein, a proper case has been made out in that the interest of justice will be served by my release on bail and that I am a suitable candidate to be granted bail. In general, I respectfully submit that I am not emotionally equipped to deal with being incarcerated in a prison, be it in my aforesaid health condition or otherwise. I further respectfully submit that I do not pose a flight risk to the state. This is supported by the fact that I surrendered myself for arrest and detention when called upon to do so by the investigating officer. I have been advised and respectfully submit that for all the reasons set out herein, the interest of justice permits my release on bail. In the premises, I pray that in the event that this honorable court finds that I am a suitable candidate to be admitted to bail, humbly request that bail be set at 10,000 rand. Your Worship, the affidavit was proposed to under oath and commissioned by the applicant on the 13th of November 2024. Each page has been initialed by the applicant together with annexures, Your Worship. They are marked on page 23, annexure B1, being the email correspondence that was referred to between the applicant and the erstwhile CEO of SAFA, Mr. Dennis Mambo. Annexure B2, Your Worship, is again email correspondence relating to media releases that were shared between the applicant and the erstwhile CEO of SAFA, Mr. Dennis Mambo, Dr. Jordaan, and the Chief Communications Officer. Annexure C is the service level agreement which was extended by the CEO that replaced Mr. Dennis Mambo. Annexure D, Your Worship, appearing on page 33, is email correspondence, Your Worship, which extensively sets out the terms of negotiation between SAFA and the applicant in respect of the extended agreement, which leads to the payment of the 345,000 rand or so that was made as alleged by the state. Annexure E, Your Worship, appearing on page 36, is the SAFA statutes. Article 37 is contained on page 37, as well as Article 39.1 that was read in the applicant's statement is contained on page 38. This is the applicant's submission, Your Worship. No further address on behalf of the applicant.
Thank you, Mr. Nwele. Will that conclude your client's application?
This, Your Worship, concludes my client's application.
Thank you. Mr. Neethling, did you understand the content of the affidavit read into the record on your behalf?
Yes, Your Worship.
Do you confirm each and every fact contained therein to be true as well as accurate?
Your Worship, there's just one small element. I'm not sure if the SAFA elective congress is happening this year. And secondly, I'm not the sole breadwinner. My wife is employed, but I am the main breadwinner.
Mr. Ndebele, did you want to attend to any amendments, or do you want to stand with the wording currently in the affidavit?
Your Worship, may I be afforded 1 minute to...
You're welcome. You're welcome to approach.
Your Worship, I am instructed that somewhere in the affidavit, although mention was not made earlier, that he's the sole breadwinner, I may have mentioned somewhere, I cannot find it. May I, with the leave of the court, move to strike out any reference I may have made to him being the sole breadwinner. I cannot, for the life of me, find where exactly that was mentioned, Your Worship, but earlier on, no mention of that was made. I think it's towards the end, Your Worship.
All right, Mr. Ndebele, if you make any amendments to the current paper, the current affidavit as it stands, you're going to have to have your client initial as well as the commissioner that did the commissioning. So it's not the aspects that your client has mentioned is not of material effect to the outcome of today's proceedings. So perhaps let's just leave it as it is. He has pointed it out. If you're happy with that suggestion, we'll stand with as it is at the moment and not start scratching out things or deleting things.
I'm happy with it, Your Worship. And also, insofar as the elective conference for SAFA, Your Worship, no indication of the timeline was mentioned. I say forthcoming elective conference. There's a conference.
Thank you. Happy with that, Mr. Neethling?
Very happy. Thank you, Your Worship.
All right. Thank you. The affidavit in support of the second applicant's application will be received as Exhibit B to the record. Thank you. You may be seated. Let's move to Mr. Hloyo, applicant number 3. Thank you.
This is Your Worship. Thirdly, to hand the agreement, which is proposed by the applicants and commissioned by the Commissioner of Court. The lead of the court and I will be copy to the record.
Thank you, Mr. Nkwashi. You may proceed reading.
Thank you, Your Worship. The regional division of Gauteng held with the specialized consultants court boundaries in the matter between Grove, Hloyo, the applicant, and the state with the respondent. Affidavit by the applicant for bail as under section 60, subsection 11, subparagraph B of the Criminal Procedure Act of 1977, CPA. I, the undersigned, Grove, Hloyo, do hereby make an oath and state that I'm an adult female Zimbabwean national, currently 55 years old, and I'm the applicant in this application. I make this affidavit on my own free volition and have not in any way been unduly influenced by any person. The facts herein contained are said were expressly indicated to the contrary within my personal knowledge and belief and are both true and correct. Where I make submissions of law, it's on the advice of my legal representatives, which advice I verily believe to be correct. I'm advised that I'll face charges of contravening section 80, subsection 2, subparagraph 8 of the Right Processing Act 17 of 1965, fraud and theft. No further details were provided to either me or my legal representatives regarding the particularities of the charges. I first learned about this investigation since the case was reported in May 2028 Boylan Police Station. I was also informed that the matter was investigated by Captain Mukhano, who is attached at the Directorate of Priority Crimes Investigations, TPCI, colloquially known as the Hawks, at number 64 River Street, Johannesburg. I've also been in constant communication with both investigators and the state through my attorneys of record. I've also pledged my undivided cooperation, and I have not reneged on my pledge. At no stage during the course of this investigation have I ever evaded or resisted to give my cooperation to the police. On 8 March 2024, the investigating team conducted a search and seizure operation in Sapa House, in particular only my office. They confiscated my web laptop and other electronic devices. Following the much publicized raid at Sapa House on 5 April 2024, the leadership of Sapa took a decision and instructed our teams of record to challenge the lawfulness and validity of the search and seizure operation through the review process, and the matter is currently pending in the High Court, Johannesburg, in the case number 2024-035799. I've been advised by our attorneys that the pleadings have closed and that the heads of argument are currently being finalized, and the matter is ready to be set down for a hearing. The state is well aware of these developments. On Thursday, 7 November 2024, my attorney was contacted by the investigator to inform him that he has a warrant for my arrest and that he needed to have a discussion with me over the phone. Indeed, the investigator also called me on 8 November 2024 and asked me a number of questions and informed me that he wanted to know, he wanted me to hand myself over for arrest on 13 November 2024 at 0700 a.m. at his office. I gave an instruction to my legal team to offer my full cooperation to Captain Mukhana in the state. However, due to the communications from the office of the senior judge who involved and needed to pen this arrest until the review is ventilated, I was advised that both the NPA and the state attorney will be preparing the answering affidavit, which is due this evening at 2000 hours, and the hearing of the matter scheduled for 10 a.m. tomorrow, 14 November 2024. I did not hand myself in for arrest. However, the police came to fetch me at my house and brought me before this court. All communications between my attorney, the state attorney, and the senior judge were forwarded to both the National Prosecuting Authority, NPA, and the TPCI, and hence I was advised that the application in the High Court would have to take precedence over this arrest. I will consider my position once I have consulted with my legal team about what has transpired here today. Previous convictions or pending cases. I'm advised that in terms of Section 60, subsection 11, capital B of Act 1977, I am compelled to disclose to this court any previous convictions or pending cases that I may have against me. I have no previous convictions either in the Republic of South Africa or elsewhere. Save for this matter, I'm not aware of any pending warrants of arrest against me. I further confirm that I do not have any cases pending against me in any other criminal courts. I'm advised that should I willfully fail, refuse, or furnish this court with false information regarding my previous convictions or cases pending against me, I'll be guilty of an offense and liable to, on conviction, to a fine of imprisonment for a period not exceeding 2 years or both. Further, that my bail may be cancelled and I may be required to remain in custody until my trial is finalized. I've also been advised that by virtue of the fact that allegations against me involve offences with the monetary value of about 500,000, my bail application falls within and has to be dealt with in terms of Section 60, subsection 11, subparagraph B, Regular Schedule 5 of the Criminal Procedure Act of 1997, as amended. As I've been therefore that it would be incumbent upon me to adduce evidence and demonstrate on the balance of probabilities that the interests of justice might raise on bail. The purpose of this application is to go to this application set out facts to demonstrate to this court that it is in the interest of justice for me to be admitted to bail rather than to remain in detention while awaiting trial. In so doing, I'm advised that Section 60 of the Act imposes stringent conditions for the granting of bail where a person stands accused of offences referred to in Schedule 5 of the Act. Section 6, subsection 4 to Section 6, subsection 9 of the Act specifically sets out factors which ought to be established by me and considered by this court before bail is or is not granted. I shall later on deal with these factors. My personal circumstances. I'm a Zimbabwean national and a South African resident, South African identity number 690817578819, and I'm employed by SAPA as its Chief Financial Officer for the past 23 years. I earn an amount of 62,000 rand per month, which goes towards my bonded property, maintaining my family, and honoring all my financial obligations, including school fees for my children and their bread. As indicated above in paragraph 1 of this affidavit, I'm 51 years old male, married to Wisdom to me, and I have 2 boys aged 24 and 21, and a daughter aged 12 years old. My children are not yet self-sufficient, therefore they are still reliant on me for their daily needs. I have household furniture, appliances, and fittings in my house to the value of approximately 500,000 rand. I have 2 vehicles, a 2018 Chrysler Voyager and a 2020 Toyota Fortuner, both valued at 200,000 and 150,000 respectively. I do not have any financial interest or assets in foreign countries. I also do not have any intentions of relocating elsewhere, anywhere beyond the borders of RSA. I owe my complete allegiance to South Africa. I live with my wife and children, and I'm taking care of them. Due to the nature of the office that I hold, I undertake to inform the state that I am required to undertake any foreign trips and produce travel itinerary as proof of my departure and return dates. The merits. I am cautioned against disclosing the basis of my defense at this stage, which advice I also accept. For purposes of these proceedings, I have detailed the manner in which I was arrested in paragraph 612 here and above. I would like to take this court into my confidence with regard to the merits of the case. However, at the time of drafting of this affidavit, the state had not provided my legal representatives with the copies of the police docket or the charge sheet. I have received a telephone call from Captain Mofano back in 2020, and I was advised to refer him to one of our tenants, which I did. That was the last time I had any contact with Captain Mofano in 8 November 2024 when he called to interview me. From the brief discussion that I had with the police about this matter, I intend to plead not guilty to all charges, and I believe that I'll be found not guilty because the evidence that they mentioned seems to be exculpatory to me. I'm of the well-considered view that this arrest is an abuse of the process because of the pending review application of the High Court as mentioned above. This is so because if the High Court finds in our favor, I would have suffered irreparable harm by this arrest and prosecution, even in circumstances where the state is well aware of the pending review application, but still elected to arraign me on these charges. The provisions of Section 6 subsection 4A versus Section 6 subsection 5 of the Act. There is no likelihood that my release on bail will endanger the safety of the public or any person, or that I will commit a Schedule 1 offense. At the age of 55, I have no previous conviction and no pending case against me. I am not a violent person, and the offenses for which I will be charged do not involve any degree of violence or threat, implicit or otherwise thereto. Section 64B read with Section 60, subsection 6 of the Act. I have strong emotional, family and community ties within the Republic of South Africa. As indicated above, I am married and have 3 children who are still dependent on me. I have been employed and assigned a lot of responsibilities by SAPA, which are very technical in nature. I have executed my duties with diligence and received no qualified audits, especially during the period of conviction. Therefore, I do not intend to jeopardize my repute or status by evading my arrest or doing anything that is likely to interfere with the prosecution of this matter. As stated above, I have known about this investigation against him for the past 5 years, and I have cooperated with the hoax. I have not attempted to flee as I believe in my innocence. For this reason, I fully cooperated with the investigating officer and handed myself in for arrest after the state contacted my attorney telephone. I trust and have confidence in the South African legal system and firmly believe that everyone deserves to be treated in terms of the rule of law. I did not commit the offenses for which I have been accused. I undertake to comply with any bail conditions pending the finalization of these proceedings. I submit that it would be unthinkable for me to evade my trial, and doing so would adversely affect the people that I dearly love, and my responsibilities which I have been employed and entrusted by SAPA for this long period. I respectfully submit that the facts that are above support my contention that I do not constitute a bias, that I have no reason not to defend my trial to proceed against it. Further, I have invested interest in seeing that justice is seen to be done. I am confident that the state will dismally fail to prove their case against me, because there will be no objective evidence that will support their case against me. I will be acquitted of the trial. Section Section 6, subsection 4C, Review Section 6, subsection 7 of the Act, in view of the fact that I do not know the specificity of the charge selected, I am uncertain whether I know the identity of the witness whom the state intends to call. I have not been provided with a list of witnesses by the state. That notwithstanding, I hold no resentment to whoever the state witnesses may be. I have no intention to interfere with or intimidate any of them directly or indirectly, and I undertake not to do so. I also undertake not to communicate with any witness, whoever he or she may be, and any other persons whose names may appear on a list of state witnesses to be provided by the state. I maintain good relationships with people and I bear no grudges against anyone. I will comply with any of conditions in this regard. I have no knowledge of any evidential material which may exist with regards to the allegations leveled against me. In any event, I believe that whatever such evidence may be, it is in the possession of the police. It is safely secured and I do not have access thereto. As stated elsewhere in this affidavit, the police conducted a raid at my place of employment, Supper House, and confiscated electronic devices from my office. Besides, I was advised that the investigations are completed and hence the state applied granted warrants to arrest us. In the circumstances, I submit that there is no likelihood that I will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Section 6, subsection 4D, Review Section 60, subsection 11 of the Act. As alluded to elsewhere in this affidavit, I still regard myself as a prominent member of the society. I've been aware of the investigation and possible prosecution since any major event, and I've done nothing to suggest that I will undermine the proper functioning of the law or jeopardizing the investigation or the state of the court. I've always waited for the legal process to take its course. And accordingly, I respectfully submit that should I be released on bail, my release shall not disturb the public order or undermine the proper functioning of the criminal justice system. Section 60, subsection 4E, Review Section 6, subsection 8 of the Act, I'm advised that the consideration under this subsection do not arise as the bail application relates to the part of institutions. Section 6, subsection 9 of the Act. I'm advised that due to the nature or the fact that this matter involves more than one accused and several charges, it is likely to take considerably a long time before it is finalized. And to respond in order to pay for my legal fees, if I'm not granted bail, I'll suffer substantial prejudice owing to my detention during trial. In all likelihood, there may be thousands of documents involved in this matter, including the ones that I submitted to the Hawks. Accordingly, keeping me in custody will also hinder me from preparing for trial advocate. I'm advised that the state has no intention to oppose my release on bail. I will comply with any condition as this court may impose. I accordingly submit that the interests of justice, considerations of prejudice, and the balancing of respective interests for my release on bail, the refusal of bail can only prejudice me and gives no benefit to the state. In the premises, I submit that I have made out a proper case to indicate that the interest of justice is releasing on bail. Should this court consider the releasing on bail, I have raised an amount of 10,000 rand to force as bail and cannot afford to stop the same. Wherefore, I will pray that this court may lead me to bail in an appropriate amount on any such conditions that this court may be. It has been posted by the Department commissioned by the Commission of Votes. It also annexes email communication between our office, the office of the state, as well as the state attorney and the director of the prosecution, the CI. I beg thee that originally proposed to affidavit and commissioned the evidence and after completing evidence.
Thank you, Mr. Nkwashu. And does that conclude your application?
It does.
Thank you. Mr. Hluyo, applicant number 3, did you understand the content of the affidavit read into the record on your behalf?
Yes, Your Worship, I understood.
Do you confirm each and every fact contained therein to be true as well as accurate?
Yes, Your Worship, I do.
Thank you. The affidavit in support of the application by the third applicant is received and marked Exhibit C to the record.
Mr. Court, please.
Thank you. Respondents?
a copy of this conviction. As submitted earlier, states not opposed to will be granted to the accused person or persons. The state's decision is advised by the information given by the investigating officer, Captain Khano, wherein he verified and or confirms the following information. Starting with accused number 1, the investigating officer confirms and or verifies that the accused stays at the address which has been referred to in the affidavit, that is married with children, that he is or he has no relatives outside of the Republic of South Africa, and that he has no income, but he is only getting honorarium from SAFA, which is determined once a year by the Remuneration Committee of SAFA, and that he has immovable assets which are valued at 5 million rands. He also has movable assets which are valued at 800,000 rands. He has a passport. And he has no previous convictions, no outstanding cases against him. And as far as accused number 2 is concerned, Trevor Mifflin, the accused is staying at the address at which it's mentioned in his application or in his affidavit. He is married with children. He is employed by Grid Communications, and he earns a monthly income of about 45,000 rands. He has no relatives living outside the Republic of South Africa. He has no previous convictions, no outstanding cases. He has immovable assets which are valued at 2 million rands, and has movable assets which are one asset which is movable, which is valued at 350,000 rand. And he has one passport which is expired at the moment. And as far as accused 3 is concerned, he is indeed a Zimbabwean citizen, but with a permanent residency of South Africa. He is also married with children and staying at the address which is referred to in his affidavit. He's employed by the South African Football Association and earns a net income of 62,000 rands. He has a passport and has traveled to countries like Zimbabwe, Namibia, and England in the past. He has no previous convictions, no pending cases, and he has no assets outside the Republic of South Africa, but he has relatives living outside of the Republic, which are his parents, who are currently residing in Zimbabwe. He has immovable assets which are valued at 14 million rands, and he has movable assets, or one asset which is valued at 200,000 rand. In considering the Section 60, subsection 4A to E provisions, the investigating officer is of the view that accused number 1 will not be a danger to the society or public, and that there is no likelihood that he will evade or attempt to evade his trial. The same goes for accused 2 and 3. The investigating officer believes they do not have any likelihood of evading their trials, and they will not endanger the safety of the public. However, the
He further informs that the following conditions should be applied to their or imposed on their bail, that they should not directly or indirectly interfere with any of the state witnesses. And on that particular point, Your Worship, the state has prepared a list of witnesses which it would distribute to the defense. I have learned that they do not know who the witnesses are, but the state would also like to give a copy to court, perhaps for it to be recorded. Second condition should be that the accused should render their passports to the investigating officer, and they will have to request the leave of the court to uplift such passports if and when there will be a need for them to travel outside the Republic of South Africa, and that they should not change their current addresses. Should they do so, they must inform the investigating officer in due course or in time. And those are the conditions that the state would like the court to impose on the accused persons, Your Worship. In as far as bail is concerned, the state is of the view that an amount of 20,000 rand would be appropriate in the circumstances, Your Worship. Unless there is any other aspect that are left behind, that would be addressed by the state, Your Worship, as a part of this.
Thank you, Mr. Balawati. Right, thank you, Mr. Nkwashu. Closing argument. You do not need to elaborate on anything except for the bail conditions suggested by the state. So it pertains to the list of witnesses. I see there's 18 names on this list. The second issue is the handing in, surrendering of the passports, and if there is a need to travel beyond the borders, that an application needs to follow to the court. And the third issue is, I hear the state is suggesting a quantum of 20,000 rand for bail. Thank you.
As stated in our application, in our affidavits, that we're in a position to raise an amount of 10,000 rand. However, that is not cast in stone. It's still left in the hands of the court. The court is of the view that a higher amount or a lower amount is appropriate. The accused will abide by that of the court. Now, as far as the further bail conditions are concerned, especially the surrendering of passports, the first applicant travels extensively. He's a South African citizen, there's nowhere else to be. He's well known around the world. He appears on international stages in football. In the very near future, the national squad of Bafana Bafana will be traveling for a game from not mistaken is either Ghana or Uganda, and accompanies them all the time that they travel. I think if the worship is to order the surrendering of the passport, it will become so cumbersome that every week, every month, we have to come to court to come and uplift, to request the relaxation of such a condition. It's our respectful view, Your Worship, that such a condition should not be imposed on him to surrender his passport, because he does extensive travels. He attends meetings of the Confederations of African Football Club. He attends meetings of FIFA. He attends meetings of a lot of sporting events which involves football or soccer. In those circumstances, Your Worship, it's our request that ever since he has known about this investigation, he has never attempted to evade arrest or prosecution. He has always remained a citizen of this country. He's always traveled and come back. And therefore there is no harm that is likely to ensue by him traveling, because when he travels publicly. It is known that he will be in this country by his diaries of public knowledge. There is no prejudice, there is no potential risk of prejudice that the state is likely to suffer by him retaining his passport. As far as the third applicant, he also travels, however, because he's an official who is based at Sapa House and works on a full-time basis. Such a condition may apply that he will surrender his passport, and with the arrangement between him and the investigating officer, he may uplift the passport from the investigating officer, travel, and then his return back to the investigating officer. Our request is premised on the fact that we do not want to burden the court with multiple applications where we have to come to court to relax such conditions, because it will create unnecessary expenses, unnecessary pressure on the limited resources of this court. Therefore, we request your worship to phrase the condition in such a way that it becomes a relationship between him and the investigating officer, that should he wishes to travel, he informs the investigating officer of his plans of travel, as well as his return date, in which he will then be handed the passport, and on his return the passport back to the investigating officer and continue with his residence and work at Sapa House. With regards to the list of witnesses, there is already an undertaking that the applicants, both applicant 1 and 3, will not interfere or do not intend to interfere with any of the witnesses that the state intends to call. And your worship would have noted from the address by the state from the bar that there is not one witness who has complained about any threats or intimidation or interference by either applicant number 1 or number 3. And therefore, there is no doubt that they intend and they will abide by this condition, not to interfere with these 18 witnesses. I'm not sure if there's anything else that is outstanding, Your Worship. However, should there be any, I'm still on my feet and I'm ready to address Your Worship.
Pertaining to applicant number 3, how often has he traveled beyond the borders? In other words, the requirement for to earn a living.
From the reading of the affidavit by the state, they mentioned 3 countries. However, I may be allowed to take instructions.
Yes, you're welcome.
Indebted to Your Worship. Your Worship indicates to me that as far as work travel is concerned, it may happen that he travels once in 2 years, and privately he travels to Zimbabwe to see his parents once a year. So the condition of surrendering his bail application also seems to be not much of a threat or not going to pose any risk to the state. However, if the worship feels that should be posed, there will be no prejudice that is going to suffer, because if he's going to get the passport once in a year, therefore it may be kept safe by the police.
Thank you. Mr. Ndebele, same indication to yourself. You can just limit your address to those 3 issues identified.
As a continuous worship, insofar as the bail amount suggested by the state indicates or proposes an amount of 20,000 rand. The applicant, accused number 2, indicated to this court that he earns a monthly income of 45,000 rand, as well as the manner in which he was arrested. Bail, Your Worship, it's for purposes of securing an accused person's attendance at court. I beg leave to request the court to grant bail in the amount of 10,000 rand, taking into account the personal circumstances, conduct, as well as the facts which were alluded to by the applicant during his application, Your Worship. Notwithstanding the fact that this is a matter which deals with Schedule 5, which requires an applicant to address the court on the interest of justice, Your Worship. Exceptional circumstances, Your Worship, bearing in mind the evidence that was submitted, Your Worship, exists. Notwithstanding that it's not a Schedule 6 offense, Your Worship. Exceptional circumstances exist in which I beg leave for this court to lean towards the request by the applicant for an amount of 10,000 rand granted instead of the 20,000 rand that was suggested by the state. Insofar as passport and traveling beyond the borders of South Africa is concerned, Your Worship, the applicant indicated that he is in possession of an expired passport. He is awaiting the Department of Home Affairs to issue the new passport which he applied for. He has no objection to surrendering his passport to the investigating officer and approaching the investigating officer as and when he needs to travel. He does not travel that often outside the borders of the Republic of South Africa. There will be no prejudice whatsoever if he needs to surrender his passport. The third aspect, Your Worship, the court may indulge me again. What is the third aspect?
The list of witnesses.
Oh, the list of witnesses, Your Worship. Absolutely no objection whatsoever. The list of witnesses, from gleaning at the names, Your Worship, are former or current executive members of the NEC of SAFA. No objection whatsoever, Your Worship, to an order being made that is not incorporated with any one of the executive witnesses. He has no business, no dealings, no interest to engage in any one of them, Your Worship. Unless Your Worship wishes me to address or any other aspect, Your Worship, no further closing submissions.
Did you and your client receive a copy of the list of witnesses?
I have in my possession, Your Worship, received the list of the witnesses.
Thank you. Then just pertaining to the bail quantum, I don't hear you, although you are requesting the court to fix bail in the quantum of 10,000 rand, you are not suggesting that your client, it's totally unaffordable should the amount be higher than 10,000 rand.
Your Worship, should the amount be higher than 20,000 rand, arrangements and means can be made. Should this court deem that the appropriate amount would be more than the suggested amount by the applicant, Your Worship, arrangements can and will be made to raise and secure such funds.
Thank you, Mr. Ndebele. Mr. Nkwashu, I just omitted to also confirm with you, have you and your clients received a list of the witnesses?
We have been provided things.
Thank you.
And from the appearance on the list, it seems that most of the witnesses are from the state and some are former employees of SAFA, so the contract is also rare.
The fact that your client, applicant number 1, is still involved with SAFA, will this not hamper his duties if he cannot make contact with any of these listed witnesses?
Not at all, Yoshi, because they are former members, they are no longer at SAFA, so
Not active.
Not active at all.
I understand. Thank you. Thank you, Mr. Nkwashu. Right, Mr. Malabati, just one aspect. The suggestion is that the request to instruct applicant number 1 to surrender his passport, that the court should not include that as a bail condition for the reasons that Mr. Nkwashu has stated. Is there anything that you wish to say about that?
Certainly, Your Worship.
I would not like to preempt what will happen to accused number 1 in as far as his position in the SAFA is concerned, but there is a likelihood that he might not be authorized for as long as this matter is pending to undertake official duties of SAFA, of CAF, FIFA, or any other association, football associations that he may be involved in, Your Worship. Knowing how FIFA especially takes this matter seriously and its reputation seriously. The likelihood is that he might not be allowed to involve himself in official duties of FIFA and its affiliates, Your Worship. Yet again, Your Worship, if a scenario arises where he has to attend to a tournament, a FIFA or rather a CAF tournament for that matter, which would be running over a period of a month, that might interfere with his appearances in court, Your Worship. And I had the suggestion by my colleague that the investigating officer should be the one liaising with the accused. And that is such a responsibility that cannot be given to the investigating officer. I am of the view and submission that the court should be the arbiter of that issue. If he has to leave, it should be on the grounds and circumstances that should be ventilated in court and be adjudicated properly by this court. If it were to be left to the investigating officer, Your Worship, it might lead to consequences that would not be in the interest of justice. That may be prejudicial to the state and to the complainants and the other witnesses in this matter, Your Worship. I therefore am of the view that the standard procedure should remain. The accused should render his passport and he will apply for its upliftment as and when that situation arises, Your Worship. And from the experience, that is general experience, human general experience, and the workings in and out of the football, the likelihood is he would not be required to be attending those many functions of FIFA and its affiliates, Your Worship. That is my turn.
Currently, we are not certain from what you are saying what the future holds for Mr. Jordaan.
Yes.
But as it currently stands, he still has commitments with SAFA until that changes, of which we are not certain about at this stage,
Yes, sir.
this moment in time. So you already informed the court you do not harbor fear that he is a flight risk and that he will abscond.
Yes, sir.
So what is your actual purpose with requesting that he must surrender his passport?
As is a general norm with many other matters that come before this court, we are always proactive. We are always trying to be uniform in our treatment of the matters. And it's standard that in our proactive stance, we need to have the accused surrendering their passports. So as not to come back to this court and lament the fact that we did not take that route, Your Worship. It's purely on the issue of being proactive and avoiding any other scenario. The accused is being given a benefit of a doubt. We do not know for sure that he would not attempt to flee, but then in order to minimize that, we have to be proactive, Your Worship. And it's from that stance that I'm requesting this.
Mr. Malabati, considering what Mr. Nkwashi said about the amount of travelling that Mr. Jordaan currently has to undertake, obviously with the provision that we don't know what the future holds for him with SAFA, but currently as it stands, it's going to put tremendous pressure on the court to weekly, bi-weekly or monthly entertain an application to whether to release or not to release the passport. So is it so undoable that I can task the investigating officer? In other words, I leave the passport with Mr. Jordaan. However, before he travels, he needs to provide a written itinerary to the investigating officer so he can always know where he is, when he's flying out, on which flight is he flying out, when he's returning, so that the IO can monitor that on his own. And if he thinks that there is a concern, he may then raise it with you, and you can then approach the court and or discuss it with Mr. Nkwashu, and then you can bring an application if need be for the court to consider more controlling bail conditions. Will you be happy with such a suggestion?
Yes, as Your Worship was addressing, something popped into my mind, and along the same lines, the thought that popped into my mind is that should the conditions of his employment with SAFA change to an extent that he is no longer required to undertake any official duties, we will then revisit this issue. But for the moment, yes, I'm amenable to the suggestion by the court.
Thank you.
By the court. If I may, Your Worship.
Yes.
There's just one little aspect that needs fixing. That is the list of witnesses. Whereas I omitted one name. It should be 19 witnesses. There's one name omitted. We've already fixed the list with my colleagues. But for the record, if I may just say it. Like I said, it has been updated with my colleagues' list, Your Worship.
And it is confirmed.
Thank you. Thank you, gentlemen. All right, thank you. You can stand up. Judgment extempore. The three applicants appear before court on what has been identified as a bail application that resorts within the ambit of Schedule 5. Section 60, subsection 11B of Act 51 of 1977, the Criminal Procedure Act, requires of the applicant to adduce evidence to satisfy that the interest of justice will permit his or her release on bail. The court has attentively listened to the supporting affidavits by the three applicants individually, received as Exhibits A, B, and C respectively. In a summary fashion, they detail the following. The first applicant is a South African male person, 73 years of age, married with 2 adult children. He has known about this pending investigation at least since 2020. He has been in constant communication with the investigating officer and the Hawks, and he has cooperated throughout. There is a review pending in respect of a search and seizure procedure which was done at the SAFA House offices. He did not surrender himself but was arrested at his residence. There is a pending interdict currently in consideration which tried to block the arrest. He has no previous convictions or pending cases. He is currently the serving president of SAFA since 2013. There is no salary income expectation to this, although he does receive a once yearly honorarium payment. There are assets, fixed as well as movable. He resides at the stated address in Morningside, Johannesburg. He has no interests or family ties beyond the borders of South Africa. Pertaining to the merits, he indicated that he intends pleading not guilty. He strongly believes that this case is merely an abuse of process. He, in general, intimates that he will not jeopardize the criminal justice system or bail system in general, and he indicated that he has bail in the amount of 10,000 rand available. Second applicant is also South African male. He's married with 2 children, of which one is a minor. He resides at the stated address in the affidavit. He has also stated income. He also mentioned his current assets, both movable and immovable. He has a Bachelor of Arts education after matriculating. There are no family ties or assets beyond the borders of South Africa. He does have a passport, which however has expired. There are no previous convictions or pending cases. He is the sole director of the entity Grid Communications, which is cited as accused number 4 to these proceedings. They provide communication services. One of their clients is SAFA. Pertaining to the merits, the applicant denies the allegation. He also believes it's an abuse of process. In great detail, he elected to enter into his relationship or the relationship of Grid, the court, to consider certain conditions pertaining to bail. Pertaining to the surrendering of the passports, it appears from what Mr. Malabate addressed the court, it is more a proactive safeguard than anything else. They also think that they can curtail any possible contact with the witnesses through bail conditions by including a list of which we now know are 19 names contained on which the applicant should not make contact to. Then there was only the slightly higher bail quantum in the amount of 20,000 Rand, which the respondent has suggested. Now, after all considered, the court is satisfied that indeed there is no reason to conclude anything other than the interest of justice will permit your release on bail. Pertaining to the quantum, first of all, I do not think that the quantum of bail suggested by the respondent is unreasonable. It appears to be achievable by all the applicants. When considering a bail quantum, the court must not fix bail in an amount which is totally beyond the reach of an applicant, which will tantamount to a denial of bail. But I do not think we are in that ambit. All three the applicants can achieve the quantum of 20,000 Rand, and as said, I don't think that is an unreasonable amount. The court will fix bail in the amount of 20,000 Rand for each of you. Then pertaining to the surrendering of the passport, we have canvassed this at length. Applicant number 2 and 3, your travelling is much more restricted. There's not such a severe need for you to have your passports. So for that reason, I'm going to make a bail condition pertaining to your handing in of the passport or surrendering it to the investigating officer. I will explain in more details the wording of that condition in a few seconds. Pertaining to Mr. Jordaan, applicant number 1, currently as the serving president of SAFA, you do have duties in order to travel, which requires traveling beyond the borders. This may change, and the wording of my bail condition that I have worded, I think will address that should there be material changes in your presidency or your position held at SAFA. We will deal with it at the opportune moment. But we need to deal with the situation as it currently stands. For that reason, I will allow you to retain your passport, and I will include some conditions in order to try to address whatever fear the state may possibly harbor in being proactive in monitoring your movement. So, gentlemen, you will be detained in custody until you have paid the quantum of bail, which is then fixed in the amount of 20,000 Rand each. Thereafter, you will be released to appear on the first of those dates will be the 5th of December, 5 December, Court 9. Towards your left-hand side, the same passage, one court to your left-hand side. 8:30 is the time to remain in attendance until excused by the court and the court only. If you fail to appear or remain in attendance, a warrant will be authorized for your arrest and the bail money will be forfeited to the state. Your legal representative cannot excuse you from attendance. It's only the court that can do so. Please understand that. While I'm on that aspect, Mr. Jordaan any travels, of which I'm going to discuss in a moment now, you need to make yourself available for court appearances. If that means you cannot attend a trip representing SAFA, unfortunately that is how it's going to be. You have your co-accused and the state that are all being prejudiced if you are absent because of an out-of-country trip. So this is the condition of why I will agree to releasing and allowing your passport to be with you. Then, pertaining to the bail conditions, applicant number 2 and 3, you are to surrender your passports then to the investigating officer for the duration of this case being enrolled. If and when the need arises to travel beyond the borders of South Africa, you can then approach the court, not the investigating officer, the court, for such a bail condition then to be considered and possibly amended. Such travels, gentlemen, are to be reserved only for emergencies and, if unavoidable, to earn a living. It is not for holidays and for other non-work or emergency-related reasons. Applicant number 1, you may retain your passport. You must provide the investigating officer with a written itinerary of your departure flight, your return flight, and your destination at least 72 hours prior to your departure. It must be in writing. This or these travels must be limited for official duties affiliated to SAFA only. If your position in SAFA changes in future, this bail condition will then be revised. Applicant number 1, 2, and 3, you have received a list of the 19 names of potential state witnesses that appear on that list. The directive and the bail condition is that you may not directly or indirectly make or attempt to make contact with any of these witnesses for any reason whatsoever. That contact, directly or indirectly, is any thinkable or unthinkable method of contact. If you, for whatever strange reason, see one of these people on the list approach you in the mall or wherever you are walking, please turn and walk off. I will excuse your conduct on your behalf to them if they feel offended because you did not greet them. Understand? Please avoid any such temptation, because if the state comes with an application that you have failed to comply with this bail condition, I promise you I'm going to play it safe. Do you understand what I'm saying? So, those are your bail conditions. Do you understand that, Mr. Jordaan? Thank you. Mr. Neethling, do you understand? And Mr. Thuyo, do you understand? Thank you. That concludes our application. Thank you.
As a purpose, Your Worship. Worship, it appears that was the last matter on the court door, and that will be the roll for the court for the day. May the court adjourn, Your Worship.
Wait until I'm